Most people think collaborative divorce means sitting in a room, holding hands, and sharing your feelings, but it's actually a structured legal process with trained professionals who keep you out of court while you solve the hard parts. In the next 14 minutes, I'm gonna walk you inside the actual meetings, show you who's at the table and why, and explain why these agreements stick better than court orders. I'm Vanessa Vasquez de Lara, a Florida family law attorney in Miami. My team guides families through collaborative cases when privacy, speed, and control matter. We make lives better in and out of family court. Sometimes that means bold advocacy. Often it means simple steps that keep you moving forward. Here's our map. Inside the process, meet the team, time and cost reality, why agreements stick, and finally, your next steps. Because you want a peaceful divorce that actually moves. You want structure, not chaos. You want privacy, not a public courtroom. And you want a plan that works in real life, not just on paper. Take a breath. You'll know you're on track when you can name who does what happens next, and about how long it's going to take you. Let's get you from guessing to grounded. This is general information for Florida divorces. Facts and court orders matter. For advice on your exact situation, talk with a Florida family law attorney. Here's what shocks people about collaborative divorce. It's more structured than going to court, not less. Collaborative divorce runs on ground rules, agendas, and shared information. Let me walk you through what actually happens. Step 1, fit check. You meet with a collaboratively trained attorney. You talk about your goals, safety, timing, and whether both sides can commit to sharing information. You decide if collaborative is a good fit or another path is safer. Step 2, the participation agreement. Everyone signs a simple contract to stay out of court and work in good faith. If someone files a contested case, both collaborative lawyers must withdraw from the case. That rule keeps everyone focused on solutions, not threats. It also protects the room so you can be candid without playing to an audience. Step 3, kickoff meeting. We set ground rules, tone, and pace. We agree on what matters most. We set the next agenda and the document list. We pick dates now so the case moves on a schedule, not a whim. Here's where collaborative saves you thousands. One neutral financial professional gathers all the documents once. No dueling spreadsheets, no fighting over whose number is right. Step 4, financial neutral gathers everything. A neutral financial professional collects the numbers from both sides, pay stubs, bank statements, retirement accounts, budgets, assets and debts, one packet, one set of spreadsheets. Now the money picture is clear and shared. Step 5, team meetings. We meet with an agenda. We use plain language. We explore options and see them in dollars and days. We assign small tasks between meetings to make sure that we keep the momentum going. If kids are involved, we translate 50-50 from a slogan to an actual schedule with decision rules. Step 6, settlement drafting. We write the agreement in clear, workable steps. It reads like instructions with dates and if-then clauses. It covers parenting time, decision-making, support, and property. No fluff, no vague promises, only terms you can follow next week. Step 7, file is uncontested. We package the agreement for the court. You sign the final agreement. Your time in court is short and procedural. The private talks stay private. Your life moves forward. Can you see yourself at that table? Are you willing to share financial information openly? Can you commit to showing up to scheduled meetings? That's the whole arc. Consult, commit, gather, meet, write, file. It's structured, not spontaneous. That's actually what makes it work. Meet the team. Most people think having more professionals involved means higher costs, but the opposite is true. When they're all working towards the same goal. 2 lawyers fighting is expensive. 2 lawyers solving with neutral professionals is different. Here's the team. Your collaboratively trained attorneys. Each of you has your own lawyer. We protect you. We keep the process on track. We co-draft a deal that will hold up in real life. The facilitator or coach. Think of the facilitator as the room runner. They set the agenda, they watch the tone, and they keep the talk productive. They help you say hard things in a way that moves the ball. When kids are involved, they help build a parenting plan that reads like a calendar. The financial neutral. They gather documents once. They build clean budgets and asset sheets. They show plan A versus plan B with numbers and timelines. They make choices visible so you're not arguing in the dark. Let me show you how this helps in real life. Here's a parenting example. You both say 50-50, but the calendar is chaos. The facilitator pulls up a week view and the school year. You agree on exchanges, school nights, and holidays. You set time sharing, the schedule for when the child is with each parent. You set parental responsibility. Who decides big things like health, school, and travel? Now you have a plan you can follow, not a buzzword you can fight about later. Here's an example about money. You both want to keep the home, but rates are high. The financial neutral shows you 3 paths. Plan A, refinance by day 90 with a buyout at X dollars. Plan B, list by day 60 with a price drop at day 90 if no contract. Plan C, rent for 12 months, then sell with a floor price and a tiebreaker appraiser. You look at the cash flow, you pick the plan that fits the numbers and your comfort level. That's progress. Which part of the process sounds most helpful to you? The neutral financial picture, the facilitated conversations, or the structured timeline? When you can point to a calendar and a spreadsheet, feelings calm down. Seeing the same picture makes it easier to solve the same problem. That's the power of the team. Time and cost reality. Here's what people get wrong about collaborative costs. They compare it to uncontested, not to contested. Collaborative isn't expensive compared to a court fight. Let's set expectations with honesty. Collaborative is not cheap or expensive by label. It's fit. The typical timeline is going to be that most cases finish in about 3 to 6 meetings over 90 to 180 days. Fewer issues means fewer meetings. More issues or outside valuations means more meetings. Speed depends on how fast both sides send documents and show up ready. What are some of the cost drivers? The number of meetings, how quickly you exchange documents, whether we need an appraisal or a business valuation, how many versions of the parenting plan you try before it sticks. Good news, a shared packet and a steady schedule cut waste. Who's a great fit? You want privacy. You'll co-parent for years and want a workable plan. You can share information. You want options and a calm room. Who's going to be a poor fit? There's an active safety concern that needs court protection right now. Someone refuses to share basic information. Someone is planning to litigate no matter what's on the table. In those cases, we'll discuss safer paths and timelines. So do a quick self-check. Do you have your basic documents handy? Can you name your top 3 goals for the next 6 months? Are you willing to meet on a schedule and use a shared packet? If yes, collaborative can shorten the road and protect your privacy. If not, that's okay. Let's design a different route that keeps you safe. Why agreements stick. Here's something most people don't expect. Collaborative agreements get followed more often than court orders. Court orders aren't the only enforceable outcomes. Collaborative agreements get filed and incorporated into the final judgment. People tend to follow what they helped write. That's a big reason these deals stick. Here's how we write it so it works in real life. Make it dated. Refinance by day 90. List a home by day 60. Exchange by 6 p.m. at the school parking lot. Dates and times are kind. They remove the guesswork. Add if-then clauses. If the refinance is not approved by day 90, then list by day 100. If the offer is below X, then get a second opinion by appraiser Y within 14 days. If a tiebreaker is needed for a school decision, then use a pediatrician or a neutral educator. If then keeps momentum when life wobbles. Write the parenting plan in plain English. Define time sharing with a week view and a holiday schedule. Define parental responsibility by topic: health, school, activities, religion, travel. Say who leads or how ties break. Clarity upfront prevents hard feelings later. Protect your privacy. Your negotiations are not public filings. The court record shows the settlement and required forms. Your private life stays private. Think about your situation. What decisions need clear rules? What schedules need specific times? What would if then clarity prevent fights about. You'll know your order is ready when it reads like instructions a friend could follow. You'll know it's strong when you can read it without calling your lawyer to translate. That's the goal. 3 real scenarios. Let me show you 3 families I've helped so you can see yourself in the process. Meet Karen and David, married 11 years, 2 kids, ages 7 and 9. Both have steady jobs. They want the kids stable and the money sane. They meet for 4 sessions. The facilitator locks the calendar and decision rules. The financial neutral models the home options and childcare costs. They pick the plan that fits the numbers and the kid's schedule. They file is uncontested. Done in 4 months. Meet Lisa and Michael, married 14 years, very busy professionals. Incomes include bonuses and stock options. Kids have sports and tutoring. The financial neutral explains how support can adjust when bonuses hit. The facilitator builds a school year plan and a summer plan. They finish in 5 to 6 meetings with a clear schedule and a clean budget. 6 months, start to finish. Meet Rachel and Tom. Mostly agreed on everything, but the tone is very tense. They keep texting always and never. The facilitator sets BIF rules. Brief, informative, friendly, firm. Meetings are shorter and more frequent. The issue list shrinks every single week. They file by the end of the quarter. Everyone can breathe again. Which family sounds like yours? Are you Karen and David with straightforward issues? Lisa and Michael with complex finances? Or Rachel and Tom needing help with their tone? If you can see yourself at that table and name your next 2 steps, you are ready. Here's what you now know. Collaborative divorce is a legal process that keeps you out of court. You sign a participation agreement to work in good faith. A facilitator runs the room. A financial neutral gathers all the documents once and shows you options in dollars and days. You meet with agendas. You write a deal that reads like instructions. You file as uncontested. Most cases wrap in 3 to 6 meetings over 90 to 180 days, depending on complexity and follow through. You keep your privacy, your schedule, and most importantly, your sanity. If you want to know whether collaborative fits your facts, take my divorce readiness quiz. It's free, private, and takes about 3 minutes. You'll get a process fit checklist, a simple document list, and your next 3 moves on 1 page. Link is in the description or scan the QR on screen. Florida cases only. This is an educational tool, not legal advice. Taking the quiz does not make us your lawyers. If there's a safety concern, stonewalling, or the need for court protection now, don't wait. Call any of my Miami or Broward offices for a free case evaluation and strategy session when available. We'll look at your facts. We'll map the safest, fast path. You'll leave with your first 3 moves. Florida cases only. Talking with us doesn't create an attorney-client relationship until we both sign an agreement. Next up, we're going to talk about the hidden cost of contested divorce. Not just fees, time loss, stress on the kids, momentum that never returns. If you haven't taken the quiz yet, grab it now. It pairs perfectly with the next video, so there are no surprises. I'm Vanessa Vasquez de Lara. We make lives better in and out of family court. I'll see you there.